Today I'm just going to do a brief overview of Ohio's product liability statute, and this is in Ohio Revised Code 2307.71 to 2307.80. In simple terms, a product liability claim is a lawsuit against a manufacturer or a supplier of a good that hasn't worked properly, has caused some sort of damage, whether it's damage to personal property or personal injury. And so it's a statutory claim that Ohio has provided. And I just want to cover a few basics today. Who the claims could be brought against, what specific claims could be brought, the available damages, and possible defenses. So just starting with possible defendants, they're manufacturers and suppliers. Those are the two that are set forth in the statute. Manufacturer, simply put, is a person or a company that designs, builds products. You're thinking your Apple designing their products. I got my Yeti right here. They're designing their drinkware. Those are the manufacturers. And then the suppliers are the companies that are selling the products, leasing the products, putting them into the stream of commerce. First that come to mind are the Targets, the Walmarts, the Amazons. Those are the big box stores. Those would be the suppliers. So those are really the two defendants that would be named in a product liability claim. Specifics of the claim. First, there's the manufacturers. There's more. It seems like there's more recourse for you against a manufacturer for specific claims. First is just a defective manufacturer of a good, and what this is, it's when the manufacturer has a good design for the product, but when it's put together, there's some sort of defect that's there when it leaves the manufacturer's possession and put into the stream of commerce. So that would be a defective manufacturer claim. There's also the second, which is the defective design claim. In this type of claim, there's a known risk in the design, and that risk outweighs the benefit associated with that design. And there's a number of factors that need to be considered. I'm not going to go over them today. That's a topic for another video, but just know that one product liability claim is the defective design. Then a third claim against a manufacturer would be a failure to warn. And in this type of claim, there's a known risk, or there's a risk that the manufacturer should have known of, and the manufacturer still puts it in the stream of commerce, but fails to either warn a consumer or instruct the consumer about that risk. So there's a potential for a claim there. And then lastly, against a manufacturer, there's a failure to conform to a representation. So if a manufacturer gives a warranty or represents some certain safety aspect of its good and it doesn't conform to that, and there is injury to person or property, there's a product liability claim for that. So those are the four claims against the manufacturer. Now there's a claim that could be brought against the supplier as well, and primarily it's one of two situations. One, if the supplier was negligent and that negligence caused injuries. That's set forth in the statute, but it's a pretty simple negligence claim that's been available by common law. And then a second claim against the supplier would be if the supplier makes a representation and the product doesn't conform to that, and the failure to conform causes the injury. There are some additional claims that can be brought against the supplier. I'm not going to go through them all right now, but in essence, some claims allow an injured person to hold the supplier liable as if it was the manufacturer. Again, that's probably a topic for another video, so I'm not going to go into that, but just be aware of that. So what are we looking at for damages? Well, there's compensatory damages. So if there is some physical injury, you're going to be able to get compensated for the physical injury. Medical expense, lost work, pain and suffering. That's compensatory damage. In some cases, If there's a flagrant disregard for the rights or the interests of the consumer that purchased the product, punitive damages can be sought. Punitive damages are more of a penalty to punish the manufacturers and the suppliers, to give them an incentive to not violate these consumer laws and look out for the safety of the consumer. So those are the types of damages you're looking at. There are some defenses that the manufacturers and the suppliers can raise. One that is set forth in the statute is assumption of risk. So if there is a known risk and the consumer buys a product, uses it, and gets hurt, there's going to be a defense to the claim. Or if the risk is just so obvious with the product that's being used, that's going to be a complete bar to the claim. Another defense is contributory negligence, and basically the defendant's going to raise that defense if the user of the product was somehow negligent when using it. In this case, that may not be a complete bar to recovery. It may reduce the available recovery, but sometimes the contributory negligence isn't exactly a complete bar in some instances. And then third, and this really pertains to all civil claims, statute of limitations. Statute of limitation is basically the time period you have to file a lawsuit after you suffer the injury. Product liability claims are 2 years. When the 2 years starts to run depends on a number of factors. Certain events may toll that statute or temporarily stop it from running, so that statute of limitations could potentially be more than 2 years after a product is purchased, or even 2 years after the injury occurs. But that is a defense that you need to be aware of. So those are just some basics of the Ohio product liability law. I plan on doing some videos, specifics, getting into some case law, just to give you some more examples, because didn't really do that, just sort of an overview of what's available. So keep an eye out for that.